I'm doing fine.
Could you please tell us your name?
Sure. My name is Jordan James.
Mr. James, what do you do?
I'm a bartender. I work at Chuggy's Bar. I'm also a musician. I'm in a band, doing what I love.
What made you decide to become a bartender?
Well, I was getting my undergrad in music, and you know, stuff happened. Bills needed to be paid. Bartending was the thing to do.
How long have you been bartending?
I've been bartending now for over 3 years. I started down south on the coast in Gulf Shores, where I worked at a local tourist trap, the Hangout. Don't ever go there. Steal your money.
And how long have you been working at Chuggy's?
I've been working at Chuggy's now for about 1.5 years.
Mr. James, are you familiar with the defendant?
I am, yes. That's Danny. He's a regular at my bar.
Now, you said he was a regular at your bar. How often did he come into the bar?
Quite often. He was one of my top customers. He'd come in a lot after work. I believe he worked nearby. $2 Tuesdays were a big night for Danny too. Thursdays were karaoke nights. He'd come in on the weekends. He was really one of my top customers.
And what kind of drinker was he?
Definitely a social one. He'd come with a lot of big groups most of the time. Chuggy's is a really relaxed environment, open space. You can bring a big group and be fine. And that's what Danny did most of the time.
And would he drink a lot when you would come into the bar?
Yes, yeah. Danny came to drink.
Now, with him drinking so much, were you ever concerned about him getting home?
Yes. Any bartender is whenever you have your customers drinking a lot. But you know, that's one of the things I like most about Danny. He was a drinker, but he wasn't a drinker and a driver.
Now, what would happen if Mr. Dawson didn't give up the keys to his car?
Well, most of the time, when he wasn't okay to drive, he would in fact give up the keys. But you know, most of the time, he'd be just as willing to hop in a taxi.
Your Honor, speculation. Yeah, proceed. How does the bartender know whether the bartender has no way of knowing whether the defendant would give his keys up or not?
Okay.
Your Honor, as the bartender, Mr. James is just testifying to his observations and that he saw Mr. Dawson regularly give up his keys because he didn't feel he was okay to drive home.
Okay, yeah, I mean, given that he's observed the behavior on multiple occasions, to overrule that is speculation.
Okay.
Now, Mr. James, I'd like to talk to you about the night of September 24th, 2010. Do you remember that night?
I do, yes.
What were you doing?
I was working. That Friday was going to be a really big night for Chuggy's. We had a concert coming in that was going to be packed that night. And so I got there around noon that day, and I was working all through the day and night.
Did Mr. Dawson come into Chuggy's that day?
He did. He came in after an interview around 2 o'clock that day, ordered some lunch, had a couple drinks with me. It was pretty quiet during that time. The concert wasn't starting till that night. So we got to catch up and just really hung out.
And do you remember why he came in that day?
Yes. He was coming in to meet a couple of friends. They were there for a 21st birthday celebration, and he was just waiting for them to get there.
And was he drinking that night?
He was.
And do you recall personally how many drinks you saw him have?
Throughout the day, I'd say I didn't send more than 6 or 7 drinks his way. Once his friends got there, they were just casually drinking with each other, enjoying the concert, and I just sent them drinks every hour or so.
And so, who made his drinks that night?
That would be me. I'm the only bartender at Chuggy's. We really don't have the wait staff to have more than one bartender behind the bar at a time. And so I was the one making drinks from noon till closing.
Now you said he had 6 or 7 drinks. Over what time period did he have those drinks?
Well, he got to the bar around 2, like I said. And him and his friends were there till almost 1 a.m. So from about 2 p.m. to 1 a.m. he had 6 to 7 drinks over the course of about 11 hours.
Your Honor, I pass the witness.
Okay.
Hello, Mr. James.
Hello?
You are the bartender at Chuggy's Bar,
That's right.
and you know the defendant pretty well.
Yes, I got to know Danny through the bar, and we also played softball together.
So you and the defendant, would you call the defendant a good friend of yours?
Sure. He spent a lot of time at the bar with me, and I served him a lot of drinks.
Does the defendant tip you well?
He does, yes.
Would you say that he's one of your best tippers?
Sure. When you have a customer come in as often as Danny does, the tips do add up, and he's one of my top customers.
Okay. Next, I would like to enter into testimony. Where is it? Your Honor, I'm sorry, I'm going to need a little bit of assistance from
Oh, you're fine.
counsel. Permission to approach opposing counsel. Thank you. I'm approaching the witness with the receipt. Are you it is customary in your line of work to keep these records?
The receipts?
Yes.
Absolutely.
And you're the keeper and custodian of these documents?
Well, sure. They're stored often in a closet in the back of the bar.
How long do you store them for usually?
Usually 3 years.
Could you please verify how many drinks are on there for me?
Sure. Now, do you want me to identify how many drinks Danny drank, or just how many he purchased?
Is that Danny's receipt that you're holding?
Sure, it was his credit card, but he was buying drinks for the whole group, so the amount on here is not the total amount of drinks Danny had.
Excuse me, can you verify that those are drinks for the whole group, or did Danny pay for those drinks?
Those are, I'm sorry, sir.
Can you do you know for sure those are for the whole group, that Danny purchased those drinks for the whole group?
Sure I do. The first few drinks were the drinks that he had from around 7 to 11 p.m. And then the next 10 drinks were drinks that he ordered for the 2 girls that were with him that night.
So you saw the girls drinking all these 10 drinks?
Sure, the 2 screwdrivers at a time were sent over about every hour.
Were you at the table to watch?
No, sir, I was not.
So you are not aware who drank those last 10 drinks?
I'm aware who the drinks were bought for.
How do you know that? Did the defendant tell you that they were for the 2 girls?
They were ordering drinks. He ordered whiskeys and also 2 screwdrivers that were sent for the other 2 people at the bar.
Did the defendant tell you these are for the other? The defendant told you that these drinks are for the other girls?
Not specifically, no. The server who takes the orders from the customers and brings them to me ordered 3 drinks for the 3 people that were at that table at that time. The 2 screwdrivers were for the 2 other people that were sitting at the bar while Danny was drinking whiskeys.
The girls were sitting at the bar with Mr. Dawson?
At a table near the concert, that's right.
And you could see the concert, you could see the table from the bar the whole time?
Sure, I mean, the bar was pretty packed. There were times I couldn't see Danny's face, but the table is visible from the bar.
So you're telling me you can account for all the drinks that Mr. Dawson drank and all the drinks that the girls drank, or the friends drank at his table?
Not specifically. Like I said earlier, I know personally, I sent 6 or 7 drinks his way through the course of the entire day.
His way? You're telling me those other drinks didn't go to his table?
I'm sorry, sir, that they were sent to his table, yes, but not for Danny to drink.
Okay. Did Mr. Dawson told you to make his drinks strong and keep them coming, right?
Danny did like his drinks on the strong side, yes.
And you did, you went with that. You poured his drinks strong and long.
I mean, sure. He was there for 11 hours, and I poured him about 6 or 7 drinks, and he likes them strong.
No further questions, Your Honor. Thank you.
Are you correct?
Yes, Your Honor. Mr. James, just to be clear, how many drinks did Mr. Dawson order for himself that night?
For himself, 6 or 7 drinks were ordered from the 11 hours he was there.
Your Honor, I have no further questions.
Okay, thank you. Can you recross?
A brief recross, I'm sorry. Mr. James, one more time, you can tell me that the drinks on this receipt you can specify.
Objection, Your Honor. The receipts aren't in evidence. This witness can't testify to the contents of the receipts.
May I respond, Your Honor?
Sure.
The receipts were entered into evidence previously.
Do we have any objection to entering the receipts now?
Yes, Your Honor. Opposing counsel hasn't laid proper foundation to enter the receipt as a business document. The witness never testified that this document was, who the document was made by, and that it was made at or near the time of Mr. Dawson being at the bar.
May I proceed in doing so?
Sure.
I'm approaching opposing counsel once again. I'm approaching the witness. Is this typical in your line of work to make these documents?
Yes, we always print out receipts whenever people order drinks.
And are you the custodian and keeper of these receipts?
That's right, the bar keeps the receipts in the back closet.
And how long do you keep these receipts?
For 3 years.
Thank you. I'm entering exhibit 4 into testimony today. Can you please?
I'm sorry, one second before. Any objection to the receipt?
Your Honor, the witness has still not testified who made this receipt and when it was made.
Okay, so the objection is on the grounds of?
Foundation, Your Honor.
Okay, I asked, are you the custodian and did you make these receipts on the night of September 24, 2010?
Yes, I did.
Thank you. Does that satisfy you?
No further objection.
Okay, your receipt's admitted.
Are you telling me, can you please specify, are you telling me that you can specifically tell me who drank each drink here on this receipt?
Each individual drink? No, but all I know is, for Danny, I didn't send more than 6 or 7 his way, and he was buying the drinks for the other 2 that were at the party that night.
His way, I'm sorry, that's very broad. Did you send all these drinks to Danny's table and watch them go there?
Yes, but I did not send all of those drinks for Danny to drink, no.
Danny told you who was drinking each drink?
No, sir. I'm sorry, Danny didn't have to tell me who was drinking each drink.
No,
When
go ahead.
When a server gives me an order, they have a specific drink for each person at the table. I make those drinks and they send them over there.
So you're telling me you don't even know for sure who ordered these drinks at the table? You're telling me the server came and told you the order?
No, sir. What I did was I prepared the drinks for the people at specific tables. That table had 3 people there. I made 3 drinks at a time, about every hour for the entire evening. That means that those 2 screwdrivers were for the other 2 people, and the whiskeys that were purchased throughout the night were for Danny. That's all I know.
But you testified that you had drinks with Mr. Dawson earlier that afternoon.
You're completely right, and I also included those drinks in the total of 6 to 7 I sent his way.
No further questions, Your Honor.
All right, thank you. Witness, step down.
The defense calls Dr. Ashley Norton to the stand. Can you please introduce yourself to the court?
Yes, I'm Dr. Ashley Norton.
Dr. Norton, why are you here today?
I'm here to talk about the validity of the blood alcohol concentration test that was performed on Mr. Dawson.
Now, before we talk about the validity of this test, let's get to know you a little better. Where did you go to school?
I received my undergraduate degree from Brown University in chemistry, and I went on to receive my master's degree and my doctorate degree from Johns Hopkins University in forensic science. After that, my husband and I moved our family here to Midland Center after I got a job teaching medicine at Midland State University.
Now, when you're called to testify in cases like these, what types of facts and data do you usually need to do that?
Well, I need the results of the test itself, of course, and I need to know what kind of model of machine was used to test the subject. And then I also speak with or look at the affidavit of the person who the test was performed on. In this case, it was Mr. Dawson, and I was able to interview him.
And did you have these facts and data in this case?
I did. I was able to interview Mr. Dawson. I was able to review Dr. Smith's results. And I know that in this case, it was an Intoxilizer 8000 that was used to test Mr. Dawson.
Now, when you do use these facts and data, what type of methods and procedures do you use to apply to those facts?
What I usually do is I make sure that all of the proper steps were used and performed. I also go through and I kind of apply my own formulas that I've learned throughout my work to kind of get an estimate of what the blood alcohol concentration should be.
Now, in this case, did you properly apply the procedures and methods to the facts and data that you had?
Yes, I applied my principles and methods to the facts that I had in this case.
Now, earlier on in this trial, you were sitting in this courtroom and you heard Dr. Avery Smith say that she's not 100% accurate, that her tests are correct.
I did.
Now, can you tell me, why would there be problems with those tests?
In this case, I have two problems with Dr. Smith's test, and I agree that those results are not accurate.
Can you tell us what the first problem was?
My first problem has to
Objection on improper opinion. Now be heard.
Yes.
When they were laying foundation for the expertise witness, one of the things they said was that she created her own methodology. We have heard no testimony elicited that this is relied upon in her field, and that we have any documentation of this methodology. Therefore, this is a proper opinion.
What I heard the witness say was, I use my own formulas that I have learned. Is that what she said?
That is correct. Formulas that she has learned from her education and experience in the field.
Okay. I would like a little more foundation on this point, especially since since we raised that issue pretty heavily with the state's experts. So I would like a little more foundation sustained.
Doctor, your formulas and methods, where did you get them? What did you base them off of?
Well, when I was receiving my doctorate and my master's from Johns Hopkins University in forensic science, we calculate blood alcohol concentrations based on a formula. It takes into consideration things like the amount of alcohol consumed, the weight of the person, and factors like that. We use this formula in my field to determine blood alcohol concentration. Now, I've testified in many cases like this, and it's the standard in my field to use this formula.
Now, you said that you had one or two problems with the test. What was that first problem?
My first problem with the test is a set ratio that the Intoxilizer 8000 uses and applies to the person who is receiving the test.
Now, doctor, I haven't taken a math class in a long time. Can you explain to us what ratios are?
A ratio is basically a comparison. It's in this case, think of it like a student-teacher ratio. You have one teacher for a lot of students. In this case, you have a lot of breath for one little bit of human blood. You're looking at a lot of breath and you're trying to figure out how much alcohol here equals how much alcohol in a little bit of breath.
Now, you showed me a demonstration to help explain this. Would it be helpful for the jury to see that demonstration?
Yes, I think it would.
Your Honor, may the witness step down and make use of the demonstrative?
Any objections?
No objection, John.
Okay, we may proceed.
May you step down?
So in this case,
Your Honor, may I move to
Silence.
in this case, like I said, the Intoxilizer uses a set ratio. It assumes that the amount of alcohol in, say this is 2.1 liters of deep lung breath will equal, thank you, the amount of alcohol in 1 cubic centimeter of human blood, represented here by this little wooden cube.
Now, this ratio, is it the same for every person that would take an Intoxilizer test?
That's the problem. This ratio does not hold true for every person. Different people can have different ratios depending on their tolerance. For example, if I'm a heavy drinker, then my tolerance could be very high, and my ratio could be all the way down to 0.9 liters of deep lung breath to 1 cubic centimeter of human blood. Now, say you didn't drink at all. So you would have a very high ratio, all the way up to 3.4 liters of human blood, or deep lung breath to 1 cubic centimeter of your blood.
Now, how does that apply to this case?
Well, the problem here is because people have different ratios, this test, it doesn't account for that. So when say I take this test and it only takes 0.9 liters of human breath to equal 1 cubic centimeter of human blood, this test, when it takes 2.1 liters of my breath, it takes too much. So, thank you. So it's going to say that I have a higher BAC because it's taking more of my breath.
Now, thank you, doctor. You can return to your seat. Now, doctor, you said that you had 2 problems with this test?
I do.
What was the second one?
The second problem has to do with something called residual alcohol in the mouth.
Now, doctor, can you please explain to the court what that means?
It's like when you eat an onion, you have onion breath for, say, 45 minutes to an hour. The same is true when you drink alcohol, when you chew gum, when you have a breath mint. That can cause alcohol to stay in your mouth for up to 15 minutes.
Now, doctor, how does the intoxilizer take into account mouth alcohol?
Well, sometimes the intoxilizer can detect mouth alcohol, but that's not true in every case. Sometimes it won't be able to detect mouth alcohol, and it will register the BAC as higher than it actually is.
Now, doctor, based on these 2 problems, how does that apply to this case specifically?
Well, the problem here is that Danny Dawson was not observed for 15 minutes prior to taking the test. So we don't know whether or not he burped or belched, if he had a breath mint, if anything like that happened to cause there to be residual alcohol in his mouth. So his BAC could be higher because of the presence of residual alcohol in his mouth.
Thank you, doctor. No further questions.
Ross?
Yes, Sean. May I proceed?
Yes.
Dr. Norton, on direct examination, you went in great detail about different factors you believe that could have caused a skewed result. However, even with these factors, you still believe the defendant was drunk on the night of September 24th, 2010.
Based on the calculations that I did, with limited amount of information that I had, his BAC could have been higher than it should have been.
But you actually believe that he was drunk on that night, correct?
Based on the information that I had, however, I'm not sure exactly how much Mr. Dawson had to drink, so I can't tell you for sure.
Yes, and you also believe that the defendant should not have been driving that night.
Objection, Your Honor. This is an improper expert opinion. She was called by the defense to test the validity of the Intoxilizer 8000 results. This is an improper conclusion.
Can I respond, Your Honor? This witness has been saying that she's dealt with the Intoxilizer test. She deals with a member's BRAC. Therefore, she is qualified to give her opinion on the effects of this BAC on an individual. Therefore, this is proper.
Yeah, and isn't the DUI statute read that you can get a conviction based on driving, quote, while under the influence of alcohol, as opposed to simply, having a BAC over .08?
Yes, Your Honor. The two elements are that you operate a motor vehicle and that you are over the legal limit. Therefore, this goes towards that element.
Okay, well, I understand your objection, but the court is very hesitant to hear you put an expert on the stand and then try to cut off questioning into any conclusion she might have reached during her analysis, so overruled.
So, Dr. Norton, even with all the factors, you believe that Dane Dawson, the defendant, should not have been driving.
If his blood alcohol concentration was in fact over .08, then yes.
In fact, with what your results show, you believe that it is inarguable to you, in your opinion, that Danny Dawson was too drunk to drive that night.
Objection, Your Honor. This is an improper legal conclusion. The Supreme Court of Midlands has ruled in cases similar to these that experts are not allowed to make legal conclusions. When the question was asked that the defendant was too drunk to drive, that is a conclusion that only the jury will be able to come up with.
Okay, can you cite some authority on that?
Yes, Diamond Design Productions v. Fountain.
Diamond Design, can I have copies of case law? Thanks.
Should be on page 3.
Okay. Okay, Mr. Campbell?
Yes, Your Honor. This says that we cannot make a legal conclusion, which would be that he drove under the influence. I'm asking for her opinion. By what happened, does she believe that he should have been driving that night? I'm not saying was his alcohol level so high that he shouldn't have been driving.
Well, I'm not quite seeing the distinction there, but what I do want to ask you is too drunk to drive a legal conclusion?
I believe so. I believe that while she can testify to what she believes the BAC was, that him being too drunk to drive is an inherent fact in this case that the jury has to come up with. They can see what the legal limit was. They can see how much experts thought it was, but too drunk to drive is.
Yeah, well, I mean, I think what the case law you cited me is about, it involves opinions on the law as opposed to facts. 704 does not prohibit an expert from giving an opinion just because it embraces the ultimate factual issue. So I'll overrule the objection.
So, Dr. Norton, from your own conclusions, you find it inarguable that the defendant on the night of September 24th was too drunk to drive, correct?
If his blood alcohol concentration was over 0.08, then yes.
And these came from your conclusions, correct?
Well, yes, if his blood alcohol concentration was over 0.08, then that would be the case, but we don't know his blood alcohol concentration.
Okay. And you believe that his blood alcohol content was around 0.08, correct?
Based on the limited information I had, that was my conclusion, but I can't tell you to a reasonable degree of scientific certainty, I'm sorry.
And that was based on your interview with Mr. Dawson, correct?
Yes, that was based on the number of drinks he told me that he had, but I can't tell you whether his blood alcohol concentration was under, at, or over.
And your opinions of that 0.08 would change if it turned out that he had more to drink that night than what he told you.
Well, I believe Mr. Dawson was telling me the truth as to how many drinks he had. What I can't be sure of is how strong those drinks were.
Yes, your opinions would also change if it turns out the drinks he had were stronger than what you accounted for.
Yes.
Therefore, that would change your results of the 0.08, correct?
Well, it would change his blood alcohol concentration.
And it would then become greater than 0.08, correct?
That's not quite right.
Now, you said that you came with 0.08 because you used a standard drink, correct?
I'm sorry, that's not right.
When you interviewed Danny Dawson to determine what his blood alcohol content should have been, one of the factors you thought of was how much alcohol is in each drink, correct?
Yes, but I didn't come up with his blood alcohol concentration being 0.08.
But you believe it should have been around it, correct?
I'm not sure. I'm not exactly sure where it would have been.
But that would have raised his BAC if the drinks that he had were stronger than what you accounted for, correct?
Right, stronger drinks equal higher BAC, but we don't know in this case. That's the problem.
But Dr. Norton, in your opinion, you believe the drinks he had were stronger.
Based on some of the things that I've heard today, that might be the case.
Now, Dr. Norton, you've testified in over 100 cases, correct?
I have.
And each and every single one of those cases has been for the defense.
Yes, police officers administer breath alcohol concentration tests, so I really am only useful for the defense.
So yes, you only testify for the defense.
Right, the state doesn't hire out private contractors.
And today you're testifying for the defense.
Right.
No further questions, Your Honor.
Any redirect?
No redirect, Your Honor.
introduce yourself?
Good morning. My name is Leslie Roman.
Ms. Roman, how do you know Mr. Dawson?
Well, I was hired by Mr. Dawson to create an accident reconstruction of the accident.
Well, what qualifies you to create an accident reconstruction?
Well, I received my degree in mechanical engineering from the University of Texas at Austin. I'm an accredited accident reconstructionist. I teach accident reconstruction classes on the side as well as driving. I also own and operate my own accident reconstruction business, and I have for the last 7 years.
All right, well, what sort of facts do you look at when creating an accident reconstruction?
Well, there's lots of things we look at, but the main things, I go to the site of the actual accident and I survey the scene. I look at the police report if there is one, and I look at photographs that the police take. I look at any relevant affidavits in the case. I also look at the vehicle and survey data there.
Did you have those facts in this case here today?
Yes, I did. I went to the site at Canyon Road and I looked at the curve, and I saw the 2009 Chevy Impala. I read the affidavits of eyewitnesses and people involved. I also was privy to the FCT report.
Ms. Roman, what sort of method do you have when conducting an accident reconstruction?
Well, I really look at 3 factors. I look at what should have happened, I look at what actually happened, and then I look at the causation.
Did you apply that method to the reliability of the facts in the case today?
Yes, of course.
Ms. Roman, when you were explaining your accident reconstruction to me, you used a picture to help me understand it. Do you think that would be helpful to the jury?
Absolutely.
Your Honor, may the witness make use of the demonstrative?
Any objections?
She can make use of the demonstrative, but the demonstrative itself is hearsay.
How so?
The writings and the picture itself, verbal and non-verbal, or out-of-court statements being used for the truth of the matter asserted. This comes from her analysis that is being used for the truth of the matter asserted, which is hearsay.
Your Honor, may I show you?
Yeah.
It's just a picture of the road. I don't believe there are any statements on this picture.
Well, I mean, it looks like we got vehicle strikes, utility pole, and rotates in a tree. Looks like we've got kind of a narrative of what happened. So I think they are statements. All right, so do you think we've got sufficient foundation for the conclusions contained on this chart here?
Would you like to see it?
Do you have any objection to her, if she were to say what's written on there?
Unless they're entered into evidence, I do not.
Okay. Well, for now, all right, we'll let you use the demonstrative if the witness testifies to anything that she's not qualified to, or if at the end of it there's still stuff on there that we haven't laid appropriate foundation for, we'll reopen the issue. So you go ahead.
Ms. Roman, could you please step up?
Yeah.
All right, Ms. Roman, can you go ahead and tell us what it is that we're looking at here?
Certainly. This is the diagram that I constructed during my accident reconstruction. It shows the events of Canyon Road at the time of the accident. This is the initial point at which the vehicle exited on the east side of the roadway. This is the 124 feet that the vehicle was outside on the shoulder. This is where the vehicle re-entered the roadway, and this is the point at which the vehicle impacted the tree and the utility pole.
Ms. Roman, before we talk about this accident specifically, I'd like to talk about that road, Canyon Road.
Okay.
What kind of road is it? I mean, I see that it's a curved road here, but is that common on that road?
Well, yes, there's a lot of curves in that area, and it's actually extremely dangerous.
Why do you say it's extremely dangerous?
Well, it's a heavily forested area. There's trees very, very close to the roadway. The tree that Mr. Dawson hit at this point is actually only 30 inches from the pavement. It's, like you said, it's curved. There's a lot of wildlife in the area. The shoulder of the road is very, very narrow, and there's a 40% downgrade, which means it's pretty steep. So if you run off the road at all, you're going to hit something, basically. And the guardrail, at this point, did not extend around the most dangerous part of the curve.
Ms. Roman, this might seem like a silly question, but what is a guardrail for?
Well, a guardrail is very simply to keep your vehicle from impacting things or running off a cliff or flipping.
Can you use this red marker to show us how far the guardrail extended prior to the accident?
Certainly. guardrail at the point of the accident extended this far. It's this line here.
Is that still the case? Is that guardrail still only extended to that point?
Objection, Your Honor, relevance.
Your Honor, it makes it less likely that the accident was a result of Danny Dawson's consumption of alcohol, and more likely that the accident and the death of Vanessa Sullivan was a result of the dangerous conditions of the road.
How so? How does a difference in the length of the guardrail a year ago and today make the cause of the accident any different?
Well, Your Honor, I believe that if the guardrail had it, today the guardrail extends beyond the point where the accident occurred, and had that guardrail been there that night, it's my belief that Vanessa Sullivan wouldn't have died, because the car would not have impacted the pole, and it would not have impacted the tree.
Well, you know, I mean, if the tree wasn't there, she also wouldn't have been dead. So how does that absolve your client of liability? Because, you know, if the road were different, you know, the girl would have been dead.
Well, Your Honor, opposing counsel is trying to show that he was being extremely reckless that night. They're trying to show that the accident was a result of his intoxication. However, in this case, because the guardrail has in fact been extended beyond the point of where the accident occurred, it offers further protection on that road to prevent accidents just like this one from happening. It shows that there was an issue with the road and that it has been fixed.
Okay, so the fact that it was changed, that the guardrail was extended, means that it was dangerous.
Yes.
The fact that they lengthened the guardrail, okay.
Your Honor, I stand by my objection. It's not relevant to the fact that what the guardrail is today from what a year ago. Furthermore, if they're using it for that fact under Midland's Rules of Evidence, they can't use the defects of a product or of a road in this case to show liability of the state.
Your Honor, may I respond to that objection? I believe that's a subsequent remedial measures objection that she's taking. In this case, it doesn't apply. Subsequent remedial measures, Rule 407, is used in product liability cases. In the wording of the rule of the law, it mentions the three things that go into a product's liability case. It mentions manufacturing defect, design defect, and a warning labels defect. In this case, we're not trying to put liability on the state, we're just trying to remove liability from Mr. Dawson. Would you like a copy of that rule?
Yeah, I'd like to see where in the text of 407 it's limited to product liability cases. So, a defective product design, or a need for warning or instruction. Well, I mean,
Your Honor, the purpose of this rule is to prevent companies from being held liable for making their products better. It's to prevent, in a product liability case, the defense from placing liability on the plaintiff. In this case, there is no plaintiff. We're not trying to place liability on the prosecution. What we're trying to do is show the dangers of the road and show how it could have been safer.
well, the state is a party to this case, and wouldn't you agree that the state could be disincentivized from improving a road if the state is not going to be able to convict somebody who allegedly was driving dangerously by extending the guardrail? Doesn't the same incentive issue about disincentivizing safer roads apply?
I don't believe so, Your Honor. I believe that in this case, if the state is correct and Danny Dawson was in fact drunk that night, they have no liability. In this case, we're saying that wasn't true, that he was not drunk that night, and that the reason this accident happened was because this road was dangerous. We're not trying to hold them liable for what happened. We're just saying that what happened was a tragic accident that was a result of the dangerous conditions of this road.
Anything more from the state?
I stand by my objection. Furthermore, what's relevant today is what happened 1 year ago, what the conditions of the road were 1 year ago, not what the conditions are today. For the reasons that the opposing counsel is using the guardrail for an extension of it today is admissible.
Go ahead and sustain the objection at this point.
Yes, Your Honor.
Move to strike the testimony of the guardrail link.
Well, I don't think there was any testimony yet about it having been changed after the accident. But if there was, that part is stricken. But the length of it, as it's shown there, is fine.
Ms. Roman, what is a guardrail designed for?
Well, as I said, the guardrail really is just to keep your vehicle on the road, to keep it from running off, possibly off a cliff, to keep it from flipping over. It's for the safety of the road.
On the night of the accident, was there a guardrail in front of where the accident occurred?
No, there wasn't.
And Ms. Roman, I'd like to talk now about the accident itself and your accident reconstruction. You mentioned that one of the first things you do is you look at what a person should have done.
That's right.
In this case, what is a person supposed to do when they drive off the road, like Mr. Dawson?
Well, I teach driving on the side here in Midlands just because I think it's really safe that we have safe roadways. It's really important that we have safe roadways, excuse me. And what I tell all of my students is that the most important thing to do in any hazardous driving situation is to remain calm and not to panic.
Why is it important to not panic?
The goal of any dangerous driving situation is to maintain control of your vehicle. And so if you panic, then there's a much greater likelihood that you're going to slam on those brakes or you're going to try to overcorrect and steer sharply back onto the road. And those two things are extremely dangerous because you can end up flipping your vehicle over.
Ms. Roman, were you able to determine what Mr. Dawson did in this case?
Well, yes, Mr. Dawson, excuse me. Mr. Dawson exited the roadway at this point in an evasive maneuver to avoid something on the road. Mr. Dawson maintained control of his vehicle for 124 feet around the most dangerous point of the curve. Mr. Dawson tried to gradually re-enter the road at this point here, where because of the conditions of the road, the slipperiness, the wetness, Mr. Dawson lost control of his vehicle and impacted the utility pole and the tree.
Ms. Roman, were you able to determine anything about the angle at which the vehicle left the roadway?
Yes, I was. The angle at which Mr. Dawson left the roadway at this point is consistent with an evasive maneuver to avoid an animal on the roadway.
Thank you, Ms. Roman. No further questions, Your Honor.
Ross?
Yes, Your Honor. Can I complete this? Yes. May I proceed?
Yeah.
Now, Dr. Norman, you've actually testified in court before.
Yes, I have.
You testified in 17 criminal cases,
Yes, that's right.
and in each of those 17 criminal cases, you testified for the defense.
Oh, yes, but I also testified for the prosecution.
But my question was for each of those 17 criminal cases, you testified for the defense.
Yes, and for the over 30 other cases that I've testified for, I have not testified for the defense. But yes, that's correct.
And you're testifying for the defense today.
That's right, I am.
The defense is paying you $200 an hour for your work,
Yes, exactly. That's my standard fee.
and you were paid $5,000 prior to trial.
Yes, I'm always paid the same standard rate.
And because you're testifying today for the defense, you're getting paid $2,000.
Yes, that's right.
Comes out to be $7,000 for your opinions in today's case.
That's right, for my accident, for my opinion in today's case.
Well, then let's talk about your opinions. Indirect, you were specifically asked to check out the possibility of Dawson's story that a deer ran into the road.
Well, yes, it's one of the things that I looked at. In accident reconstruction, we always try to look at the cause of the accident, of course. So that is one of the things I was looking for.
But you were specifically asked to do this, correct?
Well, Mr. Dawson's story. Mr. Dawson says that there's a deer in the road, so of course, that is one of the most likely causes.
Now, but you're not in a position to say whether, in fact, a deer did run into the road, correct?
I mean, I can't say with 100% scientific certainty, but the likelihood is that there was an animal in the road that night, according to my calculations.
Yes, and direct you stated that it's consistent with a deer being in the road.
Yes, that's right. In accident reconstruction, we look at a lot of angles at which vehicles exit the roadway. And so this one just makes the most sense with an animal being in the roadway.
But actually, Dr. Roman, you say that Mr. Dawson could have run out into the road for many other reasons.
Well, sure, as I stated, you can't say with 100% certainty, but my opinion is that there's an animal in the roadway.
Nonetheless, there are other reasons Mr. Dawson could have run out into the road.
Well, of course, I mean, there's other reasons.
Okay. Now, in your observations, you observed that there was a deer sign further before the crash scene?
Yes, there's a lot of wildlife in the area.
And then you would agree with me that a deer sign gives warnings to travelers that there are deer ahead?
Yes, I assume that is the purpose.
But nowhere in your documents that you read did you notice that Mr. Dawson slowed down after seeing this?
No, I didn't.
Now, you'd also agree with me that you were aware that it was pouring rain that night?
Yes, I did read several affidavits that said that.
But nowhere in your observations did you notice that the defendant slow down after given these conditions.
That's true. I mean, I really look at what I was trying to find was what actually happened during the accident, but yes, I did not state that in my conclusions.
Okay. Now, you used a formula to determine how fast Mr. Dawson was going at when he went off the road, correct?
That's right, the narrow object formula.
And you estimated that Mr. Dawson was going 51 miles per hour?
Yes, I found that Mr. Dawson was most likely going at 51 miles per hour at the point at which he initially exited the roadway.
And you're aware that the posted speed limit is 35 miles per hour?
Yes.
So you would agree with me that Mr. Dawson was going 16 miles per hour over the speed limit when exiting the road?
That's right.
16 miles per hour despite the rain conditions?
I mean, I'm not in the position to comment on Mr. Dawson's driving. However, yes, I can state that that is factually what was going on.
And factually, he was going 16 miles per hour even though he had just read that there was a deer sign.
Yes.
No further questions, gentlemen.
Okay. Any redirect?
No, Your Honor. May this witness be excused?
Yes.